me in studio, criminal defense attorney Terry Thompson and Sarah Leanne Smith-Durrett. And in our Court TV New York studio, we have criminal defense attorney Brad Micklin. Brad, to you, jury selection in a death penalty case, very difficult because you're narrowing the pool right out of the gate. There are a number of people in our society that cannot deliver a death penalty recommendation. So in this case, you're talking about not only a death case, but it's an odd case. You've got a guy that is accused of triple murder, murdering his own family, and then you add the wicked religion into it and this idea of witchcraft. For a defense attorney, what are you looking at? What are you looking for?
In potential jurors, or as far as looking for not guilty?
For a juror, who do you want to be on that jury pool if you're representing the defendant?
I think if you're representing the defendant, you want one of two kinds of people as a juror. First, you want somebody who's young, progressive, open-minded, can be used to or accustomed to alternate ways of living, alternate religions, and just understanding that everybody's different. Or you want somebody who's older because they're going to identify with this specific defendant because he is elderly and they might be more sympathetic and less likely to want to take his life.
And of course, since we did that interview, the County of Los Angeles has filed charges against Mr. Weinstein, so he is now facing charges in both New York and in L.A. Here with me, still in studio, Terry Thompson, defense attorney, and Sarah Leanne Smith-Durrett, joining me in our Court TV New York studio, defense attorney Brad Micklin. All right, let's talk Weinstein. Brad, you're in New York. Seems like they're moving forward here with jury selection. You have this appellate issue out there just waiting. I mean, the defense wants a change of venue here. The likelihood of that happening, fairly low, but a pretty good argument, isn't it? Wasn't it that they filed this motion, and there's some things in there that really do make sense.
It is a good argument, and they've made it more than once. It's not likely to be successful even on the appeal, and I'm one of the few people who don't think it's really intended to seek a relocation of the trial. I think it's more just a delay tactic, because I don't think there's any place that he can go in New York and get a fair trial away from media publicity and people having some kind of preconceived idea about it. But I think the longer that this case takes and the longer he stays out without any kind of a jury decision is better for him. And I think we're going to see more motions like this throughout the case.
Here with me to discuss this and much more, attorney Terry Thompson, defense attorney Sarah Leanne Smith-Durrett, and in New York, defense attorney Brad Micklin. Brad, the significance of the Molyneux witnesses in this case, we saw it take place in the Bill Cosby case on some level. How important is it that the prosecution has these other voices that will be able to come in and tell their stories?
I think it's crucial for the prosecution because the actual victims that are accusing Weinstein that he's facing criminal charges for are small, and raising reasonable doubt, given his fame and wealth, would not be as challenging as if you have 6, 8, 9 people with similar stories testifying against you.
Do you, as a defense attorney, go after these witnesses? Is a female defense attorney. How aggressive, though, can she get when you've got somebody on the stand telling their story the way they remember it, presumably very emotional? It's a tightrope.
It's always challenging to cross-examine a victim of sexual abuse, domestic violence, of any kind of violence, really. It really is going to depend on what the defense is, because, again, we have a number of people. So some of the defense will be, it was consensual. Some will be, it wasn't true. Some might be that they had an ongoing relationship and they're in this possibly for financial gain. So depending on what the story is will depend on how they cross-examine in New York.
Terry Thompson and Sarah Leanne Durrett are with me in studio in our New York studio. Defense attorney Brad Micklin still with us as well. Brad, to you, what stands out to you as the most significant part of the prosecution's case going into next week?
I think the most significant part of their case is going to be the similar stories that all the witnesses and victims seem to be telling. We don't seem to hear that one assault occurred in an apartment and one rape was in a hotel room. We hear stories of mutual masturbation. We hear stories that they were all in his hotel room or in a hotel room. So I think when you hear 2, 4, 6, 8 different people with very similar stories, that's going to be very compelling to a jury.
And aren't those emails that are supposedly coming in that took place between the accusers and Harvey Weinstein after the alleged assaults going to be a hurdle for prosecution? This checking in and Harvey, can we have lunch? That's not how you treat your rapist, is it?
It's certainly going to be a challenge they need to overcome, but I think part of the prosecution's case is going to be that these women had no choice, that there was a type of coercion both before and after the assaults because of his fame, because of his power, because of their career, that they didn't have any choice, and that they were forced before and after to do whatever Harvey asked them to do.
Joining me in studio all morning long, Terry Thompson and Sarah Leanne Durrett in our New York studio, criminal defense attorney Brad Micklin. As we enter into this final stage of jury selection, Brad, the defense has 7 peremptories left. Each side was given 20. That is pretty generous, is it not? Typically, you don't, as a defense attorney, have that many challenges at your disposal.
I don't think it's unusual. I mean, again, we have serious allegations. We have a high-profile case, a high-net-worth defendant, and a lot of media coverage, which has been described as a media circus. So I think there's going to be a lot of taint to a lot of jurors that come in. We've seen how many it's taken just to get this far. So I don't think it's an unusual amount.
How do you think the high-profile nature of this case changes the case? Does it help either side? Does it give Harvey Weinstein an edge, or is it a disadvantage?
It could go either way. I mean, I think there are going to be some people who think, well, this is how Hollywood is, and that works against Harvey. I think they're going to think it's believable that he would use his money and power to abuse young, pretty women, and that's just the way it was. That's why we hear terms like casting couch. Then I think there's going to be other people, younger, more open-minded, that are going to say, this is a system of beyond reasonable doubt. Can we really believe, one, that it happened, and two, that they didn't know, they didn't consent, they didn't have the stories that we now have, they didn't hear the casting couch. Even some of the witnesses, or at least some of the interviews we've heard of, people speaking that they knew in advance of the stories of Harvey Weinstein. They warned them, if you don't come back in 10 minutes, I'm going to call for help. It's questionable what they knew and didn't know going into it, and that's going to be a challenge on, I think, both sides.
Trial attorney Brad Micklin, how difficult is it to get jurors to believe a snitch, basically, someone, an informant that comes into a courtroom? What is the hurdle?
I don't think it's always that much of a hurdle. Assuming that this person's not incarcerated for lying under oath, for instance, most people assume that he or she's getting some kind of preferential treatment. First, that may not be the case. And second, you have to show that if he or she lies, it could actually be worse. So if it's discovered that they're trying to lie, they're actually punished. And you have to show that the defendant wasn't just puffing, that he wasn't just trying to act tough because he was in jail, maybe afraid for his safety. So I don't think it's that challenging to show that a snitch might be telling the truth.
Brad Micklin, in that clip that we just saw, was a situation where jurors ended up weighing who to believe more, the defendant or this guy that they brought in, this other person that was brought in. And what happened, it really, I think, affected their case negatively. It's very, well, first of all, it's very rare that you have a defense attorney bringing in somebody in that role. Correct?
Yes, because usually a jailhouse snitch is not going to hear something positive or exculpatory. Most commonly, we hear that they're being brought in to discuss something that they heard that actually helps the prosecution. But in that snippet, I wasn't sure if I heard it correctly, but it sounded like he didn't really hear directly what it was that he was testifying about.
Yeah, there were a lot of complicating problems with that witness, and over time he really hurt the defense. Criminal defense attorney Terry Thompson and Sarah Leanne Smith-Durrett still with me in studio, and trial attorney Brad Micklin in New York at our studio in Manhattan across from the courthouse on Center Street. Brad, the idea that the victims were emailing and carrying on relationships, different varying relationships with Harvey Weinstein, the alleged attacker, is that a problem for the prosecution?
It may be a problem for the prosecution. It's going to depend on the nature of the communications and the nature of the relationship. If these emails are of the nature that they're pouring their heart out to him, or trying to rekindle some kind of a relationship or build a relationship, it's going to hurt the prosecution. If it's an email or relationship that could still look like it was coerced, that was power dominated by Harvey and his ability to roll the red carpet out for their career, then it's not going to hurt them.
Yeah, and Brad, it'll have to be witness by witness, because if you start to go down that road and say, isn't it true that because of this email, Harvey may have gotten the wrong idea, you get the wrong witness who says, oh, no, there's no way he had the wrong idea. He is a rapist and he knows it. That could happen, too. How do you evaluate how far to go as a defense attorney with this type of very delicate questioning?
It's going to depend on the nature of each alleged victim's testimony, because it's going to depend on how serious of a relationship did they have before and after, what statements were made by each individual person, what did we perceive was Harvey's knowledge or intention. So everybody's going to be different, so I think they're going to need a different strategy for each of the witnesses that are going to be testifying.
Yeah, Brad, is the defense here that this is ridiculous, this idea of, my client may be a Wiccan, but Wiccans don't just murder their families, and the idea that this was a motive is absolutely ridiculous. The prosecution is grasping at straws.
I think so. I think part of this defense is going to be, and determines how it turns out when we hear from the experts, but the absence, if there is an absence, of DNA evidence. There was testimony so far, or at least reports so far, they found a cigarette butt. That's not unusual. He was there for dinner. There was evidence that they found the clothes he wore to dinner. That's not unusual either, unless there was blood spatter on it, which we don't know. They found a murder weapon, which is not unusual unless it doesn't match the forensics of the crime scene. That's going to be more important than whether or not he was practicing witchcraft.
In studio with me all morning long has been criminal defense attorney Sarah Leanne Smith, and Terry is also with me still in New York, our trial attorney. We also have trial attorney Brad Micklin. And Brad, I want to go to you first. This trial, to you, what stands out? This was huge news in Pensacola, Florida, when it happened, because it was, oh my gosh, witchcraft is part of this trial. How much of that do you want to, if you're the defense, tone down, and how much of it are you looking, during this jury selection process, how concerned are you? Because if you were tainted early on, you were a resident of this community 4 years ago when this came out, that had to be very prejudicial. If I went home watching this news, you're thinking, oh my goodness, I can't believe this story. Is that one of the threads that you're most concerned of here during this jury selection process?
I don't know if you're so concerned during jury selection. I mean, when jury selection, you're more concerned with objectivity and that they're opposed in some way, hopefully, to the death penalty. But when it comes to trial, you definitely want to try to downplay this, because the words like witchcraft and Ouija boards automatically bring up negative, scary images for people. And if that's going to be a major theme in the case, you really want to be able to play that down or negate that somehow.